I believe we've got everybody now rejoining us, all of our panel members. Can I just say a big thank you for being with us today? It's been really helpful from our side of things to see how one of these might work. And just touching on what I was saying earlier, the feedback is going to be really important for us, because this is something that we have been thinking about putting on for parents for a very long time. We're engaged in lots and lots of different events up and down the country, and obviously at the moment with coronavirus that's not possible, but generally you would see us at all of the big events, the autism show, the dyslexia show, all of those kind of things throughout the year. And obviously those aren't able to go ahead, but generally we were thinking about a live event for parents, and obviously now this has been a webinar event. So when you get that feedback form following the event today, please do fill that in and obviously give us your feedback, because that is something that we can really learn from and obviously take forward. So if you do find that it is a helpful event for you, then please do so. I have noticed some nice comments coming through on the chat, so thank you very much. It's really nice for the panelists to have given up their day today completely, obviously free of charge, to deliver these presentations for you. So please, if you have found the conference useful, please do talk about it on social media and obviously let us know as well, because that's really important for us going forward. We're just about to dive into the Q&A, and we will try to get through as many questions as possible. One last thing that I just want to make a note of, just while we've got so many parents here, because I know that there is so much information out there, is that even if you can't afford legal advice, please make sure that the people that you are going for advice are properly able to advise you. I have had an endless amount of parents that have come to me where they have gone to an advocate or they have gone to a parent representative, and then they have spent money with them and not got anywhere and had to come to get legal help after they've wasted an awful lot of money. I just flag this as a warning sign. I'm not saying all advocates are bad, but obviously there is no regulation of advocates and parent representatives like there is the SRA, and similarly for barristers as well. So I'm just flagging this as a warning. If you are at your wit's end and you need to challenge this and you're looking for support, please make sure, if you're going to get support from people, find out how many appeals they've run, find out what their success rate is. Have they just done one appeal for their own child and got a good result, or have they done this for many families? Are they keeping up to date with the case law? Do they know all of the legislation and the changes in regulations? You really need to be checking these things. And also with your expert witnesses, don't go to expert witnesses that have never been in a tribunal before, because they will be eaten alive on the day. It's a completely different ball game. Some experts are experts in delivering therapy, but not actually being in a courtroom in front of a judge and obviously facing questions from the barristers that you've seen today or from us as solicitors. So really think about who you're engaging, because the last thing I want to keep seeing land on my desk is parents that have spent money with advocates or parent reps and then had to go to legal help afterwards because you've just wasted money in the interim. So please just make those questions of anyone that's representing you, because I have no doubt they do it out of the goodness of their heart. Perhaps they've got a good result and have now set up their own kind of foundation. And also there are groups where you go in thinking you're going to get parental help, like parental groups where you go in and they just throw you onto a set of solicitors. So please just do your research before you go to these groups, and just make sure that if you're going to get advice but you can't afford legal support, you're not being pushed into legal support, or if you are seeking legal support, you're not spending money with an advocate or parent rep who perhaps doesn't have the experience to back it up. So please just do your research. I'm not going to tell you who to use. Obviously I am a solicitor, but I just want to really make that aware, because that's something that goes around on social media all the time, and through the goodness of their heart trying to help people, they could adversely affect your case. So please just bear that in mind. So having just got on my soapbox about that, we have answered today 142 questions already. So there has been a lot answered. We still have 50 open. So we will do our very best to get through as many as possible. All of our panelists will be jumping into the questions. So if I can start going through them, obviously if several people are asking the same question, you might not get your specific question asked, but we'll try and go through as many as possible. So we've got a question here. This is from Alison Chalmers, but also Joe Pike is in the same boat, it appears. The question is, can an independent special school be named in section I if it is ready to open and receive pupils, but is just awaiting an Ofsted pre-registration inspection to enable it to do so? Would any allowance be made for the fact that COVID-19 is delaying pre-registration inspections? And Joe is in the same boat and says an annual review has been triggered due to school closure. The only alternative is a new school which is awaiting Ofsted pre-inspection, and so it can gain DFE registration. And if I remember this rightly, I think I know Joe from social media, and what's happened here is her child was placed at an independent specialist setting, and that school has been closed down because of coronavirus, and now obviously she needs to find a new setting for her child to go to. So panelists, whoever wants to take the first question, please.
I have experience of this. It is possible, but you would have to have very clear evidence, and that would come from the new proprietors or head teacher. It also would have to come, I think, also from an educational psychologist working on behalf of the parents. I particularly remember getting such placements in the Shires, which is now well established and part of the Acorn Group. But it has happened in one or two other cases, Priors Court, when it was setting up, which is one of the most prestigious independent special schools in the country. So it is possible, but it's difficult. I think in the current climate, the tribunal, frankly, some local authorities are likely to be far more generous, but you do definitely need quite substantial evidence of how it's been set up, what it's able to do, how it meets your child's needs, and what vibes is it getting for Ofsted. Sometimes local authorities themselves will already have visited all of that, and your own expert will need to be able to provide input. It may also need some explanation of the financial backer if necessary, but it is possible.
Thank you, John. Next question is from Kelly Hockley. The question is, I think this is one for you, Alice, probably. Can schools try to exclude children for not adhering to the social distancing rules? For a lot of SEN children, this will be difficult to comply with, and there would therefore be a higher, appreciate it is quite a high risk of exclusion, ... discrimination.
Of course. Okay, so if you're taking a child that has a disability, and it's likely that they are going to be have a greater difficulty with their boundaries and so on and so forth, then I would bear in mind the Equality Act and the fact that that school's got to make reasonable adjustments to its behavioural policy. So a child can only be excluded for some breach of their behavioural policy, and it might be, I haven't seen schools doing this, but schools may have something written into a temporary policy or a day-to-day new way of running playground that means that you can't, jump around with other children. But reasonable adjustments would need to be made to that policy for children who have got special educational needs that might cause them to not abide by those rules or boundaries. So I think if you have a child that's being excluded or being told off for reasons like interacting with other children not being appropriate, it has to come down to the way in which the schools manage that, if it's proportionate. Of course, on the one hand, if there's a child who's running around touching all the teachers and all of the students, then you might have a greater justification from a school to say, look, we need to readjust what we're doing here and perhaps look at what support needs to be in place for this child to prevent that from happening. But I think to go straight to an exclusion for that seems to me to be putting that school at risk of discrimination claim being levelled at them. But if the proportionality aspect, I think, will depend on how great the risk is. I mean, the school would have to show that they are acting proportionately if they do exclude for those reasons. And it seems to me that they probably wouldn't be acting proportionately in those circumstances if the child's disabled. That's my view.
Thank you, Alice. That's really helpful. I think there was another question from another Kelly. I'm not sure if it's the same Kelly, but similar in regards to social distancing measures. So you've comprehensively answered that one as well. There's a question at the top. This is about entry-level qualifications. My daughter in year 11 was due to have entry-level qualifications this year for maths. However, this has now been cancelled due to COVID, and we have been told she will no longer be doing them. Instead of starting all over again at her post-16 setting, should her current school not be giving her a predicted grade in maths as the rest of the Year 11 students are getting for their GCSEs? If so, how do we go about legally challenging the school on this? Sorry, I should add, she wasn't due to sit GCSEs, just the entry-level qualifications. I'm not sure, John, I don't know if you've covered that, because I think you've done a webinar on this yesterday. So if we just unmute you.
Here I go. The answer is yes, they should be doing that, and there are off-qual criteria that require them to do so. A failure to make such an assessment and provide it to the examination body, and the information should be provided as from the 30th of May, would be a breach of the Equality Act, certainly. And it may also be grounds for making a formal complaint as well to the governing body, if this is of the college, as an additional action to take. But I would suggest threatening Equality Act proceedings would be the best way to go, because it is a plain breach.
Thank you very much, John. There's a question here which is probably more geared towards you, Nicole. It's from Kaz Devlin. It says, we have EOTAs named for summer term. The council have not set anything up. Explained why they haven't. How does this fit in under the changes to the Children and Families Act 2014?
Yeah, well, I saw that question earlier. It's kind of a combination of both you and me, really. So the position is that the education other than at school and how it should look sort of pre and post COVID should be set out clearly in Section F. So there shouldn't really be any room for manoeuvre on what should in theory be provided. But of course, as Hayley covered this morning, we do now have the notice from the Secretary of State about the Section 42 duties being alleviated because of COVID. And so that means that there is some room for manoeuvre on the part of the local authority. But if you consider the sort of your starting position should be how much of the provision, how much of the education that's contained in Section F can we possibly implement under the under the current world we're living in with COVID. I mean, I don't know how much of your education otherwise was actually already going to be delivered through virtual learning, because that's quite a common way that these programs are put into place. But for example, if the requirement was for somebody to be coming into the home, then you might find that you're going to struggle to get that put into place because of the fact that COVID-19 and social distancing has resulted in the issuing of the notice, which means that the absolute obligation under Section 42 has been alleviated for as long as the notice is in effect. I mean, I could probably advise looking at an EHC plan, but without really knowing what your education otherwise looks like, I can't really go much further than that.
Thank you, Nicole. The next question is, there's two questions kindly related to the national trial, what you get out of the national trial. It's Bethlehem Killy who says, when is the last day to register an appeal in order to take part in the national trial, which, unless Jennifer corrects me, I believe is currently the last day in August.
Yep, that's right. So it's the 31st of August, but of course you'll have a date from which you need to get in your appeal from the date of the decision letter. So make sure you comply with that deadline, but the deadline for national trial is 31st of August.
And then a question from Claire Whitehurst is, are there examples of what good EHCP looks like in relation to health and social care needs? So obviously that's EHC plans that come out of national trial cases.
Yeah, so there are exemplar guides on online, but what your EHCP looks like will depend upon the local authority. Different local authorities have different layouts and things of the plans, but what is important is the content that you request to be within those plans. So if you've got clear recommendations of social care provision and sort of health information from your GP, psychiatrists, or whoever the professionals are, just make sure that that information is the key information you request to be in the plan.
Thank you, Jennifer. Question from Jane Brooke Hughes here. What if the LA Education tell you to approach the LA Social Care for help with preparing for adulthood needs, and following a telephone call social care, you are simply told your child does not meet the threshold? How do you distinguish education versus social care provision? Is this if it is something normally delivered by social care? Nicole, I think Nicole's unmuting to talk about that. Nicole does.
Yeah, I am. I mean, that's a question, one question with actually many sort of facets there.
Yeah.
With regards to the distinction between what is education, health or social care, it's actually really quite simple, and a lot more simple than local authorities would want to let on. And that's because Section 21(5) of the Children and Families Act sets out that any provision which has the effect of educating or training a child or young person is in fact special educational provision, not health or social care provision. So that was sort of one element of the question there. The next element, if I remember correctly, being that the local authority education department have signposted this person off to social care, presumably because the young person is reaching adulthood, so it's probably 17. And that might be actually a very early warning indication that your local authority is considering ceasing to maintain your EHC plan. So that is something to watch out for. That tends to be the age where they decide that these needs have miraculously morphed. They are now social care needs, they're no longer educational needs. No need for a plan, and off you go into the realms of adult social care. I mean, I don't know what your contact with social care was. Obviously the sensible thing to do would be to request a social care assessment. The way you do that varies depending on whether you're dealing with a child or whether you're dealing with an adult, and then take it from there. But what ultimately shouldn't be happening, which sounds like your local authority are leading up to, is that your child is essentially going to fall off a cliff. So they're going to reach a point where their EHCP may or not be ceased. I would say it sounds like they're gearing up to cease, and that there will be nothing in place at all, because the transition between education over to social care has not happened at all, because they haven't picked it up. So definitely don't take them at their first answer. That isn't right. Things should be happening if he is reaching that transition point where he's going from children's services over to adult services. So I think the best thing to do is probably to formally request an assessment in writing.
The next question is from Maureen. She says, I have a son who is diagnosed with autism, is year 6 and has an EHCP. LA refused the parent choice, but instead offered a school which the parents are not happy with, because we already had a breakdown in relationships with that school. I informed the LA that I will not be consenting to that school, and the LA are now saying that they will consider safeguarding, as I am withholding my son from going to school. I need help on how to go about this.
Well,
Alex, I think you've just unmuted for that.
No, I think John was going to say, I was just going to add another principle, but no, John, go ahead.
well, we had a question very similar yesterday evening, which is why I unmuted. I mean, first of all, the situation is that if the school you've nominated is not accepted by the local authority, you should first of all appeal. And if you haven't appealed, that creates some difficulty. The local authority would be entitled to make a safeguarding inquiry. If you haven't appealed and you have kept your son at home, you could apply to Home Educate for a temporary period while you appeal. If you haven't appealed, you can apply for a statutory reassessment and see if that is the course you want to take. But we're not clear of the exact details of where you are. It sounds to me as it's a secondary transfer. They should have issued on 15th of February to 15th of March. You should be in time to appeal. So my advice is, one, appeal. I think you've probably had plenty of advice on how to conduct an appeal today, but just saying I need help is not going to solve it. You need to take action, and assuming that your son is due to go to a school in September, assuming it'll be open at all, you should be in time to appeal.
Thank you very much, John.
Alice.
I was just going to add the principle that comes from Section 19 of the Children and Families Act. So that means that the local authority, when exercising its function, has to have regards to the views, wishes and feelings of the young person and the parent when arriving at its decisions. And if there has been a breakdown in that relationship, there's some useful case law that I'm wondering where I might be able to pop it, Hayley, which does cover this point about whether or not there has been a breakdown in relationships. And every time I name case law, it's usually one that John has himself been involved in. So I'm sure that he would be able to think about this too, but there are a couple that I could think of that I'll just pop in the chat.
Thank you very much, Alice. That's really helpful. There's a question from Robbie Holland, which I will obviously touch on myself. It's a question about coronavirus. The child has an EHCP and allocated one-to-one under the current COVID-19, and school has said that the child cannot attend school because the bubble numbers cannot accommodate. The school is receiving funding for TA, but the child can't attend. Any advice? My advice would be that that is unlawful on behalf of the school, because while that they do obviously have to take into account the bubble numbers and obviously make sure children are safe and secure, the law says, and the guidance is very clear on this, that children with EHC plans are by definition vulnerable and can be provided for. We've had lots of questions about this in the chat today that we've responded to on many separate occasions. If your child has an EHC plan, you can send them into school full time at the moment. So the parents that are being told, no, you can only send your child in 1 or 2 days, that's inaccurate. And also if you're being told that you've got to keep your child at home and you're struggling, or for their needs to be met, they need to go to school, then by any means you can send them. If their current school is struggling to meet their needs because of obviously the restrictive measures due to social distancing, you need to contact your local authority, because what the position is if your own school cannot meet the child's needs at the moment, the local authority have to provide for them in an alternative setting. And I have had clients where a child's had an EHC plan and been based in a school and they have been closed, they haven't opened in line with the government guidance, and that local authority has instead arranged for that child to actually go to an independent specialist setting during this time of coronavirus, just so that they are being met full time, their needs are being met. So anyone who's being told anything about that, full-time attendance is possible, and if it's not your normal school, they will place you at an alternative setting in your area and obviously arrange for transport as is needed. So I hope that answers that for you, Robbie. The next question is from Kelly. Parents have different financial means and instructing a wide range of experts to support their case at the FTT may not be possible. Is there an expert report which would be considered a necessity above the others? And I appreciate this depends on each child's needs. Just to add my own point on that, because obviously that's what we do when we look at all of our clients' cases, obviously it is very much individual need, and it would really depend on what type of appeal you've got, is what I would say. If you've got limited funds, you need to look at the needs of that child. So if the child has a speech and language disorder, you're going to need a speech and language therapist. If you're looking to get a specialist setting, you know, you're going to need an educational psychologist. If you're looking at something like Charlotte was talking about, waking day, an independent social worker suddenly becomes crucial. So really it's going to depend on what type of appeal you've got. You will certainly need a lesser amount of experts for a refusal to assess case than you would for an against content appeal. And again, it would be very much focused on your child's primary needs and looking what they're struggling with the most to get the support in place for that, and obviously finding the evidence for the other sections. Perhaps you may be able to get some medical evidence or some NHS evidence if you can't afford experts in those areas. I'm not sure if anybody else has got anything else to add on to that section. No, okay, thank you. The next question then, if the LA agreed to reassessment on the 5th of March, are the timescales relaxed or should they be sticking to the pre-COVID guidelines? Again, sorry, this is my presentation, but anyone feel free to jump in. It would just depend when the deadline is due. It's not the date that the agreement started, it's when the decision is due. So if, for example, you made a request for an EHC needs assessment in March, on the 1st of March, and the 6 weeks takes you to the middle of April, say the 15th of April, just for namesake, then actually the deadline expired before the 1st of May. So no, it's not changed because of the regulations, because the deadline was for the 1st of May. But if they just, if you're looking for the date of the decision being due rather than the date that they've agreed to do things. So you just need to look at your individual decision when it was due. If it was before the 1st of May, then it's not amended. If it's after the 1st of May, then it is obviously amended to as soon as reasonably practicable. Okay, next question. Can special schools refuse a child with an EHCP for any reason?
No, they've got to give a reason. If it's an independent special school, they're subject to section 41, and the tribunal can order them to admit if the criteria under section 39 are met. Under section 42, in relation to any other special school, they can refuse to admit only on grounds of the fact that they can't meet need, or that the child admission would be disrupt to the efficient use of education, efficient use of resources, the other issue a local authority can refuse on is cost. But if it's a mainstream school, most of those criteria go. But a special
Thank
school
you, John.
criteria.
Nicole, I'm not sure if you want to kick this off, as you have a particular interest in social care side of things. The question is from Claire Whitehurst. Every time we request a social care assessment, we get fobbed off. How can we challenge this?
It would be helpful to know how old the child was, but difficult question to answer without knowing how old the child is. I mean, if the decision is coming back that you don't meet the criteria for a child's social care needs assessment, then the best thing that you can do is find their actual policy. It should be widely available on their website if you go looking for it, and actually set out to the local authority in a detailed letter actually exactly how your child meets the threshold for an easy.
The child is almost 13, Nicole, if that helps.
Yeah, so so that's a children's social care assessment. So what you want to be doing is looking at their policy. They will have a policy document that provides sort of their baseline for how you meet the threshold criteria in their area, and you can go through that and you can set out exactly how in your view they meet that criteria. I mean, if they continue to push back and refuse to assess and say you're not eligible for any services whatsoever, then there's potential for a judicial review claim there. If there is no law, you know, if that decision is unlawful, if it's irrational, but you would need to take specific advice on that point. A solicitor would need to look at the nitty-gritty of it to be able to advise you. We wouldn't want to send you off into the High Court without a leg to stand on. Alternatively, if this is a child with an EHC plan and you have a right of appeal, you could consider, if you have an educational basis, even if you fashion an educational basis for a need to appeal, you can get your appeal into the tribunal, request to join the national trial in respect of social care, and actually that can be a quite effective backdoor route for getting an assessment. The local authority still might resist the assessment, but then you might find that the tribunal aren't happy about that. And if you are able to commission your own independent social work assessment, you can seek then to actually get the recommendations of the independent social worker incorporated into the EHC plan, rather than what the local authority would provide, which, if they're telling you you don't meet our criteria, we're not even going to assess, I would suggest that, you know, they're probably not going to part with much.
Thank you very much, Nicole. Just as an update for the attendees, obviously we are now at the point we've answered 162 questions throughout the day today, and we still have 45 open. We are due to obviously end the conference now, but if anyone is available for the next half an hour, we will keep running just for half an hour to try and get through as many more questions as we can, because we appreciate there's lots still in there. There is undoubtedly still going to be questions in the Q&A section when we finish. We'll try to get through as many as possible. If you can see any that you would really like the list us to answer, please do hit the like, because obviously the more liked ones I will obviously jump to first as we go through in this next half an hour. But we will try and go through for the next half an hour and answer as many as possible. And at the end of the conference, if any aren't answered, we will make sure that we put up our contact details so that obviously you can channel those questions to us after the conference, or obviously contact us on any of our forms of social media. So I'll try not to waste any more time and get to it and try and get through as many more of these as possible. So the next question here, again about social care. Could you please confirm I have understood social worker element of the EHCP right? It is only for under 18-year-olds, ? When, oh, somebody else asked a question. I just lost where I was. So sorry. When you have an EHCP and a social care assessment as an adult over 18 years, is this not included in the EHC plan?
So you've got recommendations for social care for an over 18-year-old? Yes, they definitely can be in the EHC plan. That's the short answer. It doesn't stop just when the child reaches 18.
Thank you very much, Jennifer. A question from Claire. The LA Ed Psych has said that standardised cognitive assessment as part of our son's reassessment process cannot be done via Zoom, Microsoft Teams, etc. Can I challenge this?
That's both correct and not correct. So standardised assessments, in order to be standardised, do have to be carried out in a very specific way. It would require the person to be in the room to meet the criteria of the assessment to be able to produce a standardised result. It's not correct in that experts, EPs, speech language therapists are still doing assessments as far as they can via Zoom. There are verbal elements of certain cognitive assessments which can be carried out via Zoom. What the expert won't be able to do is attach standardisation to it. They will have to have a statement to say it was conducted in a rather artificial setting and that it doesn't meet the criteria for the standardisation to come into force. But it doesn't necessarily mean that they can just get away with not doing any assessments, which may well be the case in your area. They may be using this as an excuse to effectively completely halt all of the EHC needs assessment processes. So what they should be doing is looking at it flexibly. How sensibly can we do this? Can we do verbal subtests rather than having to do all of the written subtests? Can we revisit that at a later stage? So the standardisation point is right. Doing it via Zoom, there won't be standardisation, but that's not to say that they can't do something else.
Can I just come in on the back of that, actually, because one of the things that I've been saying, this point's come up a few times in cases that I've had, and one of the things that always occurs to me is we all know that there are children and young people out there who can't necessarily access standardised testing for a number of different reasons, and that's always been the case long before COVID came in. And so what I say in cases where that comes up is that the sensible thing is to go back to the expert and say, well, does this mean that you can't do any kind of assessment in the way that you would be able to if this was a child or young person who just couldn't access standardised tests for some reason? It is difficult for anybody, local authority or solicitors, to tell an expert what to do, because fundamentally the decision as to what an expert can or can't do by way of assessment is going to be for them, and solicitors and local authorities are not actually allowed to say to an expert, well, you have to do it. But I think it's always worth saying to the expert, well, imagine if there was another non-COVID-19 related reason why this young person couldn't access a standardised assessment. Wouldn't there still be useful observations that you could carry out?
Thank you, Charlotte. Question from Sarge is, can you please explain what direct payments can be used for if a PA can't attend as kids vulnerable health-wise? Can we use direct payments for other means like sensory items? I know there is a law around not freezing accounts, etc. Sorry. John, are you trying to talk there because you're...
I can...
Oh, sorry, it was you, Jennifer.
Well, let Jennifer do it then in that case. I'm happy to hand over.
Sorry. Direct payments. I think the direct payments can be used for alternative means in this, as Hayley's suggested. If you can't get the provision that you're supposed to be getting in these circumstances during the pandemic, then they need to be using reasonable alternatives. Now, if you're making suggestions about how it can be used, if they can't provide what it's supposed to be for, then you can make those suggestions and have a negotiation with the local authority.
Thank you very much, Jennifer. Okay, next question. Hi, my daughter has an EHCP and is due to start school this September, but there aren't any spaces at the specialist school for this year. So they have said about her staying at nursery until she is 5, which will be next May, but they are saying she will only be entitled to the 15-hour government-funded hours rather than a full school week. Do you know if this is right, as if there was a school place available for September, she would have been going full-time?
Well, my view is if she's entitled to full-time education, you can enforce it, and that would be by either judicial review or complaint. There are, according to statistics on the Special Needs Jungle website published by the government, I think approximately 5,000 young people, children waiting for provision. Once the local authority has issued a plan, they have a reasonable period, i.e. a few weeks or months, to implement it. If they don't, they're acting unlawfully, and some plans ought to be immediately implemented. So if the school is full, then you're entitled to find another school that can meet James or Janie's need. I don't know your child's name. And if it costs them money to send the child there, and that's immediately available, that's the law. The alternative of staying at nursery, you're entitled to insist on full-time education, as that's your child's legal right. So, in my view, the local authority are acting plainly unlawfully.
Thank you, John. The next question from Bethelyn Killy is, are you allowed to WhatsApp your team members during the digital hearing? John, you've gone on mute, sorry. Oh, there you go, Charlotte, you jump in.
Yeah. So the answer, I think, is the way that I always look at it is that if I were in a face-to-face hearing, then other people on, my witnesses and my clients would be able to pass me notes. And I normally bring with me to tribunal a stack of sticky notes so that people can scribble notes and stick them down in front of me while the hearing's going on. So when I'm doing a digital hearing, I normally make sure that I've set up some sort of route whereby clients can send me emails, perhaps WhatsApp. It depends on whether people want to disclose their telephone numbers or not. But you could also do it by way of an email with everybody copied in. You could use something like Skype chat or Google Hangouts. But yes, you absolutely can. There's no reason why people should not pass each other notes during these hearings.
I suppose the only thing that I would add is that if an expert, for example, is right in the middle of their evidence, you might not want that expert to also be texting us as counsel during it, because then I think that might pose some ethical issues about whether or not we're coaching that witness. And by that, I don't mean the parents saying, oh, can you make sure that you ask the witness this thing? I mean the expert asking me to ask them certain things in the middle of their evidence. So I think really that's more of a concern that counsel or your representative would need to worry about. And so that's really the only barrier I think of. So it might not be a free flow of messages the whole way through, but I've certainly had that, or email chains work really nicely as well.
No, I think that's right. You can't tell a witness what to say. So if your expert's in the middle of giving evidence, they'll probably be asked some questions by the tribunal. They may be asked some questions by the other side. You can't message that expert in the middle of their evidence and say, can you answer that question this way, or can you answer that question that way? But if, on the other hand, say the local authority's educational psychologist is giving evidence, then you as a parent can pass your barrister a note saying what the EP's just said is incorrect, or if you look at page whatever of the bundle, that expert's got this wrong, or something like that. So as long as you're not coaching witnesses, as Alice said, during your evidence, there's no reason why you can't pass your representative a note to say, oh, that's wrong, or this witness has got that wrong, or ask this witness about page whatever.
Thank you very much. The next question I'm going to ask from Joanna, because I think either she had some kind of nightmare with her keyboard or was so keen to ask it, she answered it 4 times. So I'll jump to her first. The question is, an individual, okay, so I'm just going to reword it. It's currently stated in section I of her child's EHC plan, and she's asking if this wording is lawful. An individualised package of education commissioned and managed by the LA to facilitate transition onto a suitable mainstream further education study programme. And she's also put the LA in any event are not putting this package together. So section I currently states an individualised package of education commissioned and managed by the LA to facilitate transition onto a suitable mainstream further education study programme. Certainly not something I've ever seen in the EHC plan. I will revert to my colleagues to see if they've had anything of that nature.
Well, Hayley, you should know the answer to that off by heart. It's a case called East Sussex v. DW, which has been followed in numerous cases. I think the last one was M&M v. Derbyshire. In section I, it must contain the name of a school or institution, and that's not a school or an institution. It should be in section F, but it's meaningless because it's not specific. It's in breach of section 37 and regulation 12. Further, so it's appealable or judicially reviewable depending on what the circumstances are. If they're not putting it in place, I think they can't argue it's unlawful if it's fairly clear what they should be doing. So the alternative remedy is complaint to the Ombudsman. If you don't want to appeal to the tribunal, go for judicial review. But they are plainly acting unlawfully.
The next question from Sally is, RLA are saying they won't accept independent CAMS consultant reports because the NHS does not have to fund the provision. Is this true?
No, it's not true. It's wrong.
Yeah, completely wrong, completely unlawful. Question from Bethlehem Killy, which I will seek to answer for you.
Hi, John, it's Simon.
Are you more likely to get an ABA package ordered by the tribunal if you opt for the trial, so that the education panel member is replaced by a health social care and the bias against therefore removed? I can see where you're going with this, because obviously not everybody is agreeable with ABA programs. However, I would advise against going on to the national trial to get an ABA program, because an ABA program is educational provision. It's not health and social care provision. So if your aim is to try and get an ABA package in place for your child, it is an educational issue and should be heard as an educational appeal. I have certainly had 2 full ABA programs that have been conceded by the local authority in a matter of weeks, and that they are both full 40-hour programs, including provision in the school holidays, and it was ruled in both of those that actually that was educational provision. So one we won at tribunal and one the local authority conceded on, and in the tribunal decision the panel was very clear that educational provision consisted of the whole ABA program, including the ABA hours in the holidays. So if you're trying to get an ABA package, I would advise going not on the national trial, unless obviously there are of social care or healthcare needs that you want to get recommendations on. Okay, next question from Eleanor. What can a parent do after the hearing if the LA experts or representatives were on a video hearing and had family members in the room? We are concerned about confidentiality for our child. Thank you.
So that's not, I don't think I've had that situation. I don't think I think I've yet to be in a hearing where any of the representatives or the judges or the witnesses have family members in the room. It's a really clear breach of the rules of the tribunal, because hearings are supposed to be in private. I mean, I assume that we're talking about something more than somebody's toddler staggering in to hold up a toy or ask for a biscuit or something like that. If we're talking about somebody, an adult being in the room for a prolonged period of time as opposed to a sort of domestic interruption, then I think I don't know that it would. It's interesting, actually. I'd be interested to hear what John thinks about this. I don't think that it would necessarily result in the tribunal's conclusions being affected, but I do think that it's a pretty stonking breach of the tribunal's rules around privacy, and you would be entitled to complain to the Court and Tribunal Service.
I think current guidance does say the tribunal will be understanding if there are family members in the room. I think it's all a matter of scale. It may be a breach of confidentiality, but obviously it may be that people just have small places and that there isn't anywhere else to go. I'm lucky to be able to borrow this room and not have 3 dogs barking every time somebody makes a big noise past the door or comes to the door. But it would be something that, you know, the tribunal would have to put up with. But I can see circumstances in which the situation is that in these circumstances there will be other people hanging around. I think if there is a concern about that for the future, you should, to others listening, you should simply say, I think this is a breach of confidentiality. I don't want this hearing to continue. In the present case, all you could do is write a further formal complaint to the tribunal's Deputy Chamber President, Merrilee Tedder, or the Chamber President, who I can't remember who it is at the moment, about the breach of confidentiality. That would be a possibility. But as Charlotte has said, that wouldn't give you the right to set the hearing aside if that's what's in your mind. But it is a concern, but it is all dependent on the individual circumstances.
Thank you, John. Question from Paula is, can the LA refuse to formally consult with an independent non-specialist school if it best meets the child's needs?
Yes, simple answer to that. An appeal issue.
Okay, next question we're going to go to. Is there any data to show that parental wins for educational provision are more likely when a panel member is a health or social care member than an education member? Certainly there's no formal statistics on this. I'm not sure if the barristers have got anything to feed back from your experience in tribunal, or if there is no clear data on that.
I haven't noticed any particular tendency one way or the other. I don't think. I mean, I think what happens in a national trial case is just that you basically have a social care expert, or possibly a health expert, depending on what the main issues are, tacked onto your panel. So you've still got your panel of judge and education expert. You've just also got a social care expert in there as well. What I would say is that the social care members tend to be very obviously more interested in the social care issues than in the other issues that arise in the hearing, although it can vary from tribunal to tribunal. I don't think it's possible to say that they have an effect on the educational side of the appeal.
Thank you very much, Charlotte.
I just think it's worth adding, statistically, the government, the special needs jungle asked the tribunal, not the government, how many cases recently on their statistics local authorities won. And the answer was astonishing, 4%. Bearing in mind when the great Mark Small was in charge, they managed to get to 12%. Their win rate has dropped by 300%. Now, that doesn't mean to say the parents get the school they want, because that statistic wasn't available, but it does indicate that local authorities are doing very badly in the tribunal because of the way they present their cases and prepare them. So I can't say any more than that. The fact that the national trial is available and there are different experts on it doesn't seem to have helped them, is all I can say.
Thank you very much, John. Just because we're pushed for time, I can see that Steve G has asked a question about LA saying that post-19 education may be for 2 or 3 years at most, and how often is it possible to assess until 25? The answer to that is very possible. There are lots of children and young adults that go on to EHC plans until they're 25. And we have just literally done a blog post on this only this week. So if you head over to our website and go onto our blog post, there's a blog post specifically on this issue, Steve. So if you want to familiarise yourself with that, that will give you the answer to that question. There's a question now specifically for you, James. The question is, what happens when our evidence of failings of a school is contradicted or denied by the school? My experience is that the professionals are always taken as being honest and that we parents are venting. How can we best present evidence when it is their version of the truth against ours? And I don't know if you want to give an answer, and people may jump in on that as well.
Yeah, that's fine. I mean, I do GDPR request to school to find out what their records actually say. And I'd also look for expert evidence to contradict what the school is saying as well, because your experts are unlikely to agree with the school. Then you'll have expert evidence on your side for the appeal process, which the tribunal will take account of. And that would be my view on that.
Yeah, I mean, just building on what James has just said, figures don't lie. So, you know, if your child's been at the school for a good period of time, there will be data in their possession which will evidence lack of progress. There may also be internal emails between members of the school or with the local authority which actually set out that the position that the school are putting forward at the tribunal isn't the accurate one, and that's far more common than you might think. Data Protection Act requests can really be a goldmine in terms of actually showing, evidencing that the child just isn't making progress within that educational setting for whatever reason. So definitely Data Protection Act requests.
Can I just quickly leapfrog on the end of that? Really look at how the school is benchmarking progress, because a lot of them will measure progress by reference to the EHCP outcomes. The EHCP outcomes may be very old, they are certainly going to be very broad, and tribunals actually are normally quite switched on about not just going, well, these outcomes have been met and therefore progress has been made. So, you know, be ready to, or get your experts to really be ready to drill down into the school's evidence of progress, especially when their assessment figures are not matching with that.
Thank you very much, Charlotte, as well. Question from Christine is, after tribunal, we had requested full-time one-to-one for my son. The judge didn't agree. However, they did not specify and quantify how much one-to-one my son could have, as they did agree he needed it some of the time. Where can I from here to get that clarified in the EHC plan?
I would say to the upper tribunal if you have time to appeal. If the problem is that the EHC plan, if the problem is that the tribunal has found that if you've got a definite factual finding that your child needs one-to-one for some of the week, and they haven't specified how much it is, then I would say that's potentially an appeal point.
Thank you very much, Charlotte. Another question here, I have requested a direct payment for me to transport my son to school. However, Transport have assessed my son as needing a taxi to school. I don't agree, as other children will be at risk. Where do I stand with obtaining a direct payment to transport him myself?
Well, the transport
John, should come in on that. I think you've frozen. Oh, no,
I'm going now. Well, the transport should be suitable, and it should be suitable for your child. And I'm really struggling to envisage the scenario in which the local authority are wanting to provide a taxi rather than let you transport yourself, because you transporting is going to be cheaper. So that's a new one on me. Normally it's the complete opposite way round, where parents want a taxi and the local authority are going to try to encourage you to drive 4 hours on the school run every day, because they're only going to pay you a nominal sum per mile. But if it's not suitable for whatever reason for your child to go in a taxi, you know, I suppose that you could argue if they were with an unfamiliar person that they're more likely to have challenging behaviours. They would need, in addition to a driver, they would need a one-to-one personal assistant or transport person in the car with them as well, which is going to make it very uninviting for the local authority, because it's going to be cheaper, more expensive. But if what they're trying to do is shoehorn him into a taxi route that's already running, it might be that that would be cheaper. But again, if that is going to place both your son and the other children, young people in that taxi at risk of harm, then the transport isn't suitable. And you should really go back to them and drill down into exactly what is it that they're proposing and set out exactly why that is not suitable, non-stressful transport for your child.
Thank you very much. There's a question here from Louise, which I will attempt to answer. If I want to try to get an EHC plan for a young child, 2.5 years, what evidence should I submit? Will the LA dismiss an assessment because my child isn't in preschool school yet? The answer to the second part of that question is no. And if they do, it's unlawful, because EHC plans can be obtained for children from the age of 0. So definitely not because of an age factor. The kind of evidence that you would need to submit is really dependent on your own individual child. I think James made this clear earlier on in his presentation. There is no minimum requirement for, you know, you have to be 3 years behind your peers or anything like that. It's the individual needs of the child. So any medical evidence that you've got, certainly evidence of any diagnoses. If you're putting in private therapies, you need to disclose that as well. And if you're funding any extra provision, also if they are being taught in a nursery or anything similar at the moment before school, then actually what provision are they putting in place as well? Because all of that additional support that may require an EHC plan does need to be specified and obviously popped into the assessment request. So that is what I would say in addition to that. A question from Alison Chalmers, and I think we've probably got time for about 3 more questions because we're really 181 question answered and we've still got 41 coming through. So we'll probably answer just 3 or 4 more, and then I will ensure the details go up for any further questions. So Alison Chalmers, it's one for you, Nicole. Would EOTAs typically come with a personal budget, or would the LA typically commission the provision direct, but with it being delivered at home?
Well, it depends. I mean, if you wanted to request a personal budget so that you could organise it for yourselves, then that's a matter for you. The local authority wouldn't necessarily have to agree it, and there are personal budget regulations which set out the considerations that the local authority would have to take in determining whether or not to arrange a personal budget or agree to a personal budget. But personal budgets are not always ideal. You'll often find that the local authority, in terms of funding, won't provide enough funding to make all of the provision. You'll find yourselves in arguments. For example, if you needed to commission a speech and language therapist and the going rate for an independent therapist in your area is £80 an hour, but the local authority claim that they have an agreement which means that they can get it for £40 an hour, well, the £40 is all that they're going to give you. So it can be, some parents do like it. They like the freedom that it gives them to arrange the provision themselves, but often they can be more than they're worth. And given once COVID is all behind us, hopefully very soon, and the notice is no longer being enacted to lessen the Section 42 duties, if all of the provision is specified and quantified in Section F of the EHC plan, the local authority are under an absolute obligation to provide it regardless of the cost. So in terms of enforceability, you're probably far better off just making the local authority stump up the cash and not involving yourself in a personal budget.
Thank you very much, Nicole. Question here, more suited to your presentation, James, from Red Fox. What a brilliant name there. Draft EHCP details. So draft EHC plan details needs in section C and D, description of needs, but LA is refusing to include, as a professional didn't write, in the summary of needs in section G and section H. How can I contest? Also, diagnoses details B, C and D, but not the needs arising from the diagnoses. How can I get professionals to detail so I can have provision and outcomes? I think what this person is trying to say is that the needs for their child has been put into section C and D, obviously rather than the educational sections, because the local authority is trying to pull a fast one. But James, do you want to touch on that?
Yeah, so it sounds like they don't want to put it into section B, which is where the special educational needs should be specified. And that might be due to the fact that they don't want to provide the provision as such, because if needs are specified in section B, then they will have to provide provision in section F to meet those needs. And it's likely it could mean that you may need to face an appeal to the SEN tribunal to change the plan to have the needs specified in section B, and then to have the correct level of provision put in section F. It's very likely you need expert reports to comment on that, and then they would be able to advise on what goes in where in terms of section B and section F, whether they are special educational needs, for example, and whether that is special educational provision.
Thank you very much. 2 more questions that we'll talk through and then we'll put the details up. Question from Claire. If you send a complaint to the LA regarding the authority not carrying out an EHC reassessment correctly and ask for an acknowledgement of receipt and for a response within 5 working days, and you receive no response whatsoever within a week, what would the next steps be? This sounds to me like a judicial review for unlawful or irrational behaviour that's being written from a parent direct.
You're correct.
Yeah, so in that case, I mean, they tend to have much better power if they come on solicitors' headed note paper. I only tend to say that because I issue pre-action protocol letters all of the time in lots of my cases and don't seem to have this issue. The local authority do respond to solicitors. So all I can say is, obviously, I'm not sure if you have the means, but obviously you may want somebody to write on a solicitor's letter for you. Certainly it sounds like it's a pre-action type letter, and it might just be that your local authority, while you don't need to be a solicitor to certainly make a pre-action protocol letter, local authorities often don't take parents seriously, as you'll all know from going through this minefield, because they don't think that they will actually take them to judicial review, whereas the threat is obviously greater coming from a solicitor's firm. So if that is the case, and that is what is going on there, that probably is why, because the local authority do not think you will go through with a judicial review, and they're obviously chancing their luck as to not responding to you. Okay, final question. I'll try and find one that's been liked several times to get the most out of it for everybody. Just bear with me. Okay. My children were due a review last July and October, and we still haven't had it, and they are due to leave school, both in year 11. I applied for a specialist school, but panel due to sit in June, and I don't know what will happen next.
Anyone?
Does anyone want to take that?
Yeah, no, I'll take it. Well, you're in a position because we're now very, very late in the year. And if your children are coming up to the end of their secondary schooling and moving off into post-16 education, then actually the reviews at the very latest should have happened in November of 2019. And your final EHC plans naming the setting that they're actually going to be attending from September should already have been issued. So you're very much on the back foot, and it needs urgently taking in hand. And that, as Hayley just touched upon, by this point I would be saying get a solicitor to send a pre-action letter for you, because what you don't want to do is go down the rabbit hole of trying to make complaints and make up time, because we're already in June and the tribunal is already listing appeals in October. There's a good chance that you already wouldn't be able, if you can't agree setting, to get this sorted out before September. So time really, really very much of the essence for you. And I would say get a solicitor, get a pre-action letter out and get things moving.
Thank you very much for that, Nicole. Unfortunately, we are going to have to draw our question and answer session to an end. We've had an absolutely brilliant day with you all, although we physically can't see you. Although I did have a very panicked parent phone me today who used to be an employee here and we used to work together, to say, are you sure you can't see me, because I'm in my pajamas? So definitely no, we can't see you, but we hope you've certainly enjoyed being in our company today, and we really enjoyed you coming along, and I hope you found it really worthwhile. Just a reminder, we've managed to answer 186 questions today individually on the chat, so it's certainly been no mean feat. There are still 39 questions open, so apologies if we have not managed to get to you directly. What we are going to do after the event is, as I've said, we will be emailing you with a feedback form. Please fill that feedback form in, because if you found this event useful, the success of future events does rely on you coming back to us to say how helpful it was. So please do, obviously, positive and negative, we're open to all feedback. We will also include on there our contact details. So if you didn't have a question answered and you really have a burning desire to get that question answered, you can obviously use those details to contact us. Obviously, myself and my colleagues, Nicole and James, both working at SEN Legal, and Alice, Charlotte, Jennifer and John working at 3PB Chambers. But we're all a very big team here, and we all work together regularly, so we can make sure that your question gets to the relevant person. So we'll make sure that we send that out to you, and we'll send the feedback. Just one of those key questions on the question answers. If you fill in the feedback form, it will ask you where you want your recordings to be sent to. All of the talks have been recorded individually, so they will all be sent to you. Just pop your email in there and you'll have the feedback recordings and you'll have the slides. So other than that, all we can say is thank you so much for joining us today. We've really appreciated you know, doing this alongside your very, very busy lives and managing children and dogs for the poor Nicole, who's been picked on many times today. But we hope you found the event useful, and we look forward to doing another one soon, should you require one going ahead. So thank you very much. That's all from us, and look out for the email.
Sure.